This video examines the Supreme Court case of Cambila Jr. versus Seabren Security Agency. We will explore the legal arguments surrounding compensable working hours and the evidentiary value of time records in this landmark labor ruling. In this case, the Supreme Court of the Philippines, 3rd Division, with Associate Justice Henri Jean-Paul B. Inting as the ponente, addressed key labor standards, specifically focusing on compensable hours worked and the evidentiary value of client-signed daily time records. The parties involved were the petitioners, security guards Lorenzo D. Cambila Jr. and Albahar S. Samad, who claimed 12-hour shifts without overtime pay, the respondent, Seabren Security Agency, their employer, and the client, Ecoland 4000 Residences, where the guards were deployed. The guards were assigned to Ecoland 4000 from 2008 to 2018. They claimed they worked 12-hour continuous shifts daily. When they requested mandated salary adjustments, they were reportedly relieved, leading to their subsequent complaints for illegal dismissal. Seabren Security Agency defended itself by presenting a, quote, duty detail order, arguing they implemented a, quote, broken period shift. They contended that a 4-hour interval in the middle of the day was non-compensable personal time, thereby excluding it from overtime calculations. The contested schedule featured a shift starting at 7 a.m., with an alleged 4-hour break starting at 11 a.m., resuming at 3 p.m. until 7 p.m. The Supreme Court had to determine if this gap was actual time off or compensable waiting time. The labor arbiter initially awarded the guards 957,000 pesos. The findings noted the 4-hour break was too brief for effective personal use. The NLRC affirmed this, concluding the agency used this scheme specifically to avoid paying overtime. The Court of Appeals later reversed the decision, deleting the overtime award. It argued the daily time records were self-serving because they were countersigned by the client and not by the agency's own timekeeper, lacking evidentiary value. However, the Supreme Court ultimately ruled that DTRs countersigned by the client's manager are prima facie evidence of hours worked. The client is best positioned to monitor attendance, and the lack of an agency signature does not invalidate the records. The court clarified that under Article 84 of the Labor Code, working time includes time required to be on duty. Because the break was too brief for personal use, and the agency admitted guards stayed on site, the quote, broken period was seen as an effort to circumvent the law. In its final decision, the Supreme Court reinstated the overtime award, stating that justice must favor the worker when employer schemes erode labor standards, leaving no doubt that the 12-hour workday was compensable. The key takeaway is that employers should avoid broken period schemes unless they allow true personal freedom. For workers, client-signed logs remain powerful evidence of hours actually rendered. This concludes our review of the case. The sources for the images used in this video are listed here for your reference.